Good afternoon, everyone. Welcome. I'm Rick Hasen of UCLA School of Law and the Safeguarding Democracy Project. I'd like to welcome you to the final installment of our Fall 2024 series on issues related to the fairness and integrity of the 2026 midterm elections. You can find videos of our earlier events from this semester as well as earlier events at our website, which is safeguardingdemocracyproject.org. And we hope to soon be announcing the schedule for our winter and spring events. As always, all of our events are free, but advanced registration is required. I want to thank Harley Ham and Ben Austin DeCampo for their important logistical support today. You'll find information in the chat if you're a California lawyer and are seeking MCLE credit. Reach out to Ben Austin DeCampo, the coordinator of the Safeguarding Democracy Project, if you have any questions about that. And if you have any questions today for our panelists, please feel free, if you're watching this live, to put them in the Q&A box, and I will try to get to some of those near the end of our program. Today, we're pleased to feature a webinar with Samantha Blencke of the Native American Rights Fund, Ellen Katz of the University of Michigan, and Deuel Ross of the Legal Defense Fund. The topic we'll be discussing today is the Supreme Court, the Voting Rights Act, and the 2026 elections. I'll briefly share a small piece of their bios, but their full biographies will appear as links in the chat on Zoom. Samantha Blencke is managing attorney of the Native American Rights Fund's Washington, D.C. office, where she leads a national litigation to protect the voting rights of Native Americans. Her work has secured major victories expanding ballot access, enforcing the National Voter Registration Act, and establishing on-reservation polling places across multiple states. She currently represents the Chippewa Cree tribe and Native voters in a Voting Rights Act challenge to at-large county elections in Montana. Ellen Katz is the Ralph W. Eigler Professor of Law and Associate Dean for Academic Program at the University of Michigan Law School, writes and teaches about election law, civil rights and remedies, and equal protection. Katz's scholarship addresses questions of minority representation, political equality, and the role of institutions in crafting and implementing anti-discrimination laws. She's published numerous articles, including an influential empirical study of litigation under the Voting Rights Act, which has been cited, I think, multiple times now by the United States Supreme Court and many lower courts. And Deuel Ross is Director of Litigation at the Legal Defense Fund. He supervises cases related to equal educational opportunities, protecting equal access to the political process for African American and others. He has extensive experience litigating in these areas. Among that, he successfully argued the Allen versus Milligan case just a few years ago before the Supreme Court. All of our authors are really experts in the field, but I've asked them to speak to an audience. Some of you are voting rights experts and some of you aren't. So we'll try to keep the discussion, at least to start, at a relatively high level of generality, and then we can get into the nitty-gritty, especially as the program goes on. So please join me in thanking our panelists for coming here today. Please, panelists, feel free to unmute yourselves and put your mics on. And what I've asked is for each of the panelists to speak for about 5 to 7 minutes, just kind of setting the stage on various issues. I've asked Deuel to talk about the Louisiana versus Calais case, which he's involved in. I've asked Samantha to talk about issues in the Eighth Circuit involving the private right of action to sue to enforce Section 2 of the Voting Rights Act. And I've asked Ellen to kind of give us a 30,000-foot view of where we are on voting rights and Voting Rights Act litigation in the country. So with that, thank you all. Let me turn it over to Deuel.
Thank you so much, Professor Hasen, and it's really great to be on this panel and with such a really illustrious co-panelists. So let me give you a very broad overview of what's going on with voting rights right now, particularly in light of what the Supreme Court's decision, Louisiana versus Calais. So what happened in Louisiana is several years ago, at the same time that LDF and others were litigating the Alabama redistricting case, we were litigating a Louisiana redistricting case. And in that case, we alleged that Louisiana, which has 6 congressional districts, only one of which is majority Black, despite the state having about a 30% Black population and growing and a shrinking white population, had violated Section 2 of the Voting Rights Act, which is a broad prohibition against any kind of racial discrimination in voting. And that law has been used for the last 40 years to essentially force states across the country, as well as city councils, school boards, local districts, to draw districts in which Black and other voters of color have an electoral opportunity. Those are often majority minority districts, although there could be other kinds of districts that states draw in response to Voting Rights Act challenges. LDF and our clients won that case. And in response, after a lot of back and forth, Louisiana decided to draw a new majority Black district. They didn't draw a majority Black district, though, like the one that we had said was possible, which would have been based primarily in Baton Rouge and sort of south eastern Louisiana. Instead, they drew a district that sort of stretched from Baton Rouge all the way up to northern Louisiana near Shreveport. And after we won, and after the state enacted that map, a group of non-minority voters, essentially white voters, challenged that map and called it an illegal racial gerrymander. And what that means is that the Supreme Court has essentially said there's sort of broadly two kinds of race-based claims. One is the Section 2 claim that I described, which is essentially that states didn't draw enough districts in which minority voters had an electoral opportunity. And then the other kind of claim that the Supreme Court has mostly dealt with are called racial gerrymandering claims. And those claims are basically that the state used race too much, that they set racial targets, that they sorted voters based on race. I think the very classic example is from the 90s, in which states would draw what essentially looked like ink blots, or just trying to grab minority voters all over the state, no matter where they live, and the Supreme Court has said that using race in that way to just draw voters together solely based on race, not based on, the cities in which they live in, communities of interest, compactness, all these things that we traditionally think about with redistricting, that is unconstitutional and illegal. And so these white voters essentially alleged that the state of Louisiana, in drawing this new district, had used race too much. The case got in front of a three-judge court, which has an immediate appeal to the United States Supreme Court. There's no intermediate court. If you sue challenging a state congressional or legislative district as being unconstitutional, it goes to three judges. They decide the case, and then it goes automatically to the Supreme Court. The three-judge court in this Louisiana case that ultimately got called Louisiana versus Calais. So you hear me referring to Calais. This is what I'm talking about, is this group of white voters challenging the second majority minority district in Louisiana. Won their case very, very quickly back in 2024 in the spring. The Supreme Court, though, put that ruling on hold, essentially saying it was too close to the election to change Louisiana's maps, and then heard argument on it earlier this year in the spring. We thought the Supreme Court was going to rule in June. They didn't. They essentially punted and said, we're going to decide this Louisiana. We're not just only going to decide whether this specific second majority minority district in Louisiana is constitutional. We're actually going to decide whether the Voting Rights Act itself is constitutional. And as I said at the beginning of my spiel, the Voting Rights Act is a law that broadly prohibits racial discrimination in voting. The Supreme Court has slowly certainly over the last 15, probably over the last 20 years, been chipping away at the Voting Rights Act and make it harder and harder for voters of color to win Voting Rights Act claims, harder for them to prove that they need a new opportunity district or majority minority district. And now the Supreme Court, in the Calais decision, the second go around of argument, is deciding not just whether or not Louisiana should draw a second majority minority district, but whether the Voting Rights Act itself is constitutional, where it's even constitutional to require states to engage in any kind of race-based redistricting. And so there are sort of a number of pathways in which the Supreme Court could go. There was the re-argument in the Calais decision was just in October, so almost slightly more than a month ago, so October 15th. We're expecting the Supreme Court to issue a decision quickly. A lot of what you're saying now in terms of redistricting, obviously there's the partisan angle to it, in which states are sort of being bullied either by their constituents or by the president to redraw their congressional districts. But it's also in part in response to I think some states thinking that the Supreme Court is going to give them a freer hand after Calais, and being able to draw districts without having to draw districts in which minority voters have an opportunity to elect candidates of their choice. In many places, that has a partisan component. It doesn't always. There are places like Texas in which drawing majority minority districts doesn't, and Florida as well, doesn't necessarily change the partisan composition of a district. But the Supreme Court, if they did say that the Voting Rights Act was constitutional, or if they just made it a lot harder for plaintiffs to win those cases, or if they decided that using race in a particular way when you're drawing districts is unconstitutional. All of those things, which I can get into more detail, but would make it much more difficult for plaintiffs to win these cases. And it would also allow states to continue with their current path of sort of redrawing districts in a way that is, in my view, illegal and unconstitutional. And I think people probably saw today in Texas, in which the state of Texas was found to have violated the Constitution in the way in which they drew their new Texas districts. That obviously some of that will be implicated by what the Supreme Court decides to do and how much the court says you can or can't use race in redistricting, or whether or not the Voting Rights Act itself is unconstitutional. So hopefully I've summarized that quickly and succinctly enough, Professor Hasen.
Well, very well. I mean, in fact, you can see that you're an experienced Supreme Court advocate. Give you 2 minutes, 5 minutes, or an hour, you'll make it fit the time. Before I turn to Sam, I just want to come back to just one thing you said, which is you're expecting a ruling quickly. I mean, quickly by Supreme Court standards, not like it comes in a week.
Yeah,
But what I wanted to ask you is like, but since the title of this talk is about the 2026 midterms, what do you think the chances are that we get a decision that could potentially impact the redistricting standards, either the
yeah.
existing lawsuits over the redistricting, or perhaps a round of redistricting in light of that opinion this year?
Yeah, it's really hard to say. I mean, the Supreme Court clearly heard re-argument on this case and knows when the midterms are. Louisiana's Secretary of State in its briefing said that she needed a map by mid-January. And so the Supreme Court at least has that date in mind. Now, whether the court can write an opinion that whoever the majority is, feels good about in that time, I don't know. Supreme Court is also, as we're going to hear here, going to conference this Friday on three other redistricting cases. The Alabama case is back up in the Supreme Court after a trial court win earlier this year. The Turtle Mountain case that I know Samantha is going to talk about, another Mississippi case. And so it could be that we hear from them on all four of those cases, Calais and these other cases, soon. It could be that the court puts it off until June. It's really no way to know.
All right, thank you for that. And Sam, you're going to tell us about kind of a completely different aspect of this Section 2 litigation in relation to a case out of North Dakota.
Right. Thanks, Professor. Yeah, I'm sort of going back to the beginning here. So Turtle Mountain, it wasn't just a redistricting case. It, along with the two cases that Deuel just mentioned, is really going to put front and center the core question of whether communities themselves can still enforce Section 2. So private enforcement by private litigants, it's been the backbone of Section 2 of the Voting Rights Act for 60 years, since 1965. So if it disappears, the right itself becomes very difficult to use. So just a little bit about Turtle Mountain. We represented Turtle Mountain and Spirit Lake and three individual Native voters in challenging North Dakota's 2021 legislative map. It had reduced from 3 to 1 the Native districts, despite both tribes, Turtle Mountain and Spirit Lake, asking to be unified. So we filed a complaint in February 2022. And after a 4-day bench trial, numerous exhibits, numerous witnesses in the summer of 2023, the district court applied Jingles correctly. Jingles, of course, is the 1986 Supreme Court case that sort of established the standard for how a vote dilution case can be brought. The district court found a Section 2 violation, and then they imposed a remedial map. That was appealed to the Eighth Circuit. The Eighth Circuit didn't touch those factual findings or the Jingles analysis. And instead, it held that private plaintiffs can't enforce Section 2 via a statute called 42 USC 1983. It's basically just a civil rights enforcement statute. It's the only circuit in the country to reach that conclusion. So go back a little bit more. In November of 2023, in another case, Arkansas NAACP, the Eighth Circuit had held that Section 2 doesn't have a private right of action within the statute itself. So that's why Turtle Mountain and Spirit Lake also brought this other means under Section 1983. So in our case, the Eighth Circuit went even further, and in May of this year, and said that Section 2 can't be enforced under Section 1983. And I'm going to get a little legal here, but I think this will make sense because in their view, they said the statute does not unambiguously confer an individual right. That's despite the statute saying that it protects the right of any citizen to vote free of racial discrimination. So it doesn't quite jive. Um, and then they also based their conclusion on some uncertainty that they had already established from the Arkansas NAACP case. There was a dissent. The Chief Judge Colleton dissented. He emphasized that every other circuit to consider this issue had allowed private suits. It's really not a close interpretive question. The Eighth Circuit was an outlier. Um, this decision was extreme. It had immediate consequences in 7 states. The voters themselves could no longer go to court to protect their right to vote under Section 2. So that's 21 million people, including 13 million eligible voters. So the plaintiffs there filed a cert petition with the Supreme Court. It's been fully briefed, and it's scheduled for conference this Friday, along with the 2 other cases that Deuel mentioned, the Milligan case, which is also about the private right of action within the statute itself, and Mississippi NAACP, which is about the private right of action itself. So here's what's at stake. So if private litigants can't sue to enforce Section 2, that leaves the Department of Justice. There's somewhere between 1 and 3, maybe 1, 2, 3 attorneys left in DOJ's voting section. So there really is not a DOJ voting section right now. We estimate that without private enforcement, somewhere between 95 to 99% of Section 2 litigation disappears. So tribal nations, tribal communities, the people we represent that rely on Section 2 to break these long-standing structural barriers, they lose their only viable tool. So it's really about whether minority communities, Native Americans, other minorities get to participate equally in democracy. And so when elected officials draw maps that dilute the power of Native votes, and then the courts say that the Native people can't challenge those maps, it just breaks down democracy. So here's what it looks like on the ground. In North Dakota, under the remedial map, the Native voters were able to elect their 3 preferred candidates in 2024. So that restored the representation that they had consistently had before the enacted map had collapsed their districts. But under the Eighth Circuit's decision, they wouldn't even have had the right to bring that case at all. So I'll just apply this. I know you mentioned the Choteau County case. We actually just settled that case on Friday. So I'll just apply what this looks like in a very recent case, a smaller jurisdiction. There, the Chippewa Cree tribe in Montana sued Choteau County for at-large districts. These are old Jim Crow style, stereotypical way to dilute a minority's voice. And it's a pretty clear, straightforward Section 2 violation. The tribe started to reach out to the county in 2023 to say, hey, your map violates Section 2. Can we work together? Here's a consent decree. And the county never replied. There were meetings, there were emails, there were letters. So the tribe had to sue. Like I said, we went to settlement on Friday and were able to settle. But their reactions are non-reactions after 2023. It shows what Section 2 is designed for. When elected officials refuse to fix an obviously discriminatory structure, the affected communities have to have that legal remedy. And voluntary change wasn't going to happen without the Section 2 threat. And then without that, Native voters in Choteau County would have continued to have zero meaningful representation on the county commission. So next summer, SCOTUS is going to decide this question, this really basic question, whatever vehicle it is, if Turtle Mountain is the vehicle or those other cases, are direct appeal. So it will decide it in some form or fashion. Is Section 2 a right that communities can actually use? Or is it a right that exists only on paper? And for Indian country and many other minority communities, that answer determines whether fair representation is realistically achievable.
Thank you for that. And before I turn to Ellen, I just want to talk a little bit procedurally about the stay that the Supreme Court issued. So what does that mean? What does it mean for right now? And does that send any signal about what the court's going to do next?
I hate to read the tea leaves and have too much hope here, but we have a little hope because there was a stay. The Supreme Court stayed the Eighth Circuit's decision. The remedial map is still in place in North Dakota. that signaled to us that, we thought that cert would be granted. That said, it's been rescheduled a few times now, so I'm not sure if that's the case. Um, I think this issue is going to have to be decided though, because the Eighth Circuit right now is the only circuit in the country that doesn't allow these Section 1983 claims. So, like I said, whether it's the Turtle Mountain case or some other case, I think this is going to be front and center before the Supreme Court, and we'll see a decision in the summer of next year.
Thank you for all of that. And now, Ellen, you've been studying voting rights for a long time and have kind of looked macro and micro at these cases. So if you could share your perspective, I think we'd all appreciate that.
Sure. So thanks, thanks to Rick and to Ben for putting this together. It's really great to be on this panel, and I appreciate the opportunity. I'll just add a few thoughts to what's already been said. These are pending cases, so of course we don't know what's going to happen, but I think they both portend really consequential things that could follow. And as Samantha just pointed out, I'll start with Turtle Mountain. For all practical purposes, Section 2 litigation will cease if the Supreme Court grants and then affirms what the lower courts did here, and makes the ban on private enforcement of Section 2 a nationwide prohibition. Our Michigan study says that found 97% of all Section 2 cases have a private litigant. 85% only have a private litigant. Those ones in between where there's both DOJ and involvement and a private participant, often DOJ has gotten involved after private litigants have followed. So we really would see the end of all litigation under Section 2. If the court says no in Turtle Mountain, which for what it's worth, I'd be surprised, and doesn't grant cert, there will be no Section 2 litigation in the Eighth Circuit. There's no public litigation alone in the Eighth Circuit. And it is an area of the country that accounts for almost half of all the cases brought by Native American tribes under Section 2 since 1982. So it would be a real big effect, even just letting this one stand. On Calais, one reasonably likely outcome to my mind is that the Supreme Court, the justices eliminate Section 2 dilution claims going forward. That would be immensely consequential. Here we estimate almost three quarters of all Section 2 cases since 1982 have been dilution claims. And that doesn't account for the extent to which Section 2 has been incorporated in the way state and local authorities, when they draw maps, know Section 2 is out there. And so draw maps knowing, well, if we draw it this way, we're going to get sued. So let's draw it this way. Or in fact, have been sued 10, 20, 30, 40 years ago and have a district that is descended from that and maintain it as a result. So the consequences there will be enormous if that in fact happens. I want to say a few more words about Calais, but before I do, I just want to sort of point out something else that these two cases have in common. And that's that they're both addressing, or will address if Turtle Mountain's taken, questions that the justices themselves initiated. These didn't arise in the normal course of litigation. Justice Gorsuch, back in the Brnovich decision, invited the private right of action cases by raising the question that really those of us who've been thinking about this for a long time thought had been wholly settled long ago. And then, of course, we know, as Deuel's told us, that the Supreme Court held Calais over and presented a new question last spring, or last summer was when the question was posted. The oddity about that question in Calais, actually, where they ordered re-argument on the question of whether Louisiana's intentional drawing of a second majority minority district violates the Constitution, is a kind of an odd question, because the lower court had already answered that question and said, yes, it does, holding that race predominated when Louisiana drew the second district, and that the Voting Rights Act, the Section 2 of the Voting Rights Act, didn't require it. And that left the Supreme Court with an option, right? It either could have affirmed it last spring and instructed Louisiana to draw a new map, or it could have reversed, either reversed by saying race did not predominate over traditional districting principles, which is what Louisiana had originally argued in the case, or it could have said race predominated, but Section 2 required it. And I think the reason the court didn't like either of those options is they both left this intentionally created majority-minority district in place, and that there's a number of justices who think that's illegal or unconstitutional, that Section 2 cannot be read to require that. And that turns on a question that Deuel has already mentioned, which was the litigation that predated this litigation, the Robinson litigation, in which a lower court found that the plaintiffs were likely to succeed on their claim that Louisiana violated Section 2 by failing to draw a second majority minority district. That's the question. If you listened to oral argument last month, it came up again and again, a sense from various justices that Louisiana could not be required, that Section 2 should not be read to require the intentional creation of a majority minority district on the facts of this case, or to my mind, on the facts of this case, mean on the facts of any case. If it's not required here, it's really difficult to imagine a place where it would be. So, and I'll wind up, I know Rick has a lot of questions. He wants to talk about Texas and other things, but I just want to say a couple of things about what would happen. Why might it be unconstitutional for compliance with Section 2 to require states to intentionally draw majority minority districts? Because that's where the case seems to be going. And one reason is one that's been lurking for 30 years, and that's the City of Bernie congruence and proportionality standard that was raised a bit in oral argument. For what it's worth, I don't think that's where the case is going to go. I can be proven wrong easily. I think rather the court's going to hold something less sweeping than that, but sweeping nevertheless, on this dilution claim that you can't intentionally create a majority minority district, that doing so involves too much thinking about race. It's making race too much front and center. And critically, not just that it's making race front and center, but that it's not justified. And not justified, and here's what's kind of remarkable at the moment we're at, not justified as a remedy for a Section 2 violation. That remedying racial discrimination in voting pursuant to a statute that Congress put in place cannot be done with this kind of remedy that itself is race conscious. And it's difficult to overestimate the sweepiness of such a holding. It would basically legalize racial vote dilution in the United States going forward, and it would further entrench sort of the limits we've seen on the Equal Protection Clause. And just to cabin it, just to think about like a case like SFFA or something like that, which is limiting use of race-based decision-making in pursuance of diversity as a goal, says nothing about using a race-based remedy to address racial discrimination. And that's really what we're talking about here. I think I'll talk much more, but I'll stop there.
Thank you. That you gave us a lot to chew on here. I just want to go back to one point, which I think you're not the first one to say this, but I'm having trouble wrapping my head around the idea that the court could say that Section 2 still stands when there's, you could meet the Jingles factors, for example, show that there's racially polarized voting and that the minority group could be large enough to create a majority minority district or a minority opportunity district. But then you can't use race to remedy. You can't be race conscious when you remedy that. So what would the remedy look like? Would it be a hollow remedy? Like, would it be a remedy in name only? Is this just like a way of striking down Section 2 without saying it? Or is there some way that you could race neutrally respond to a proof of a Section 2 violation?
So I mean, my answer is I don't know. I mean, I don't know how it's going to write. I suspect it's going to overrule Jingles. I mean, I think that is a likely holding here. And I think part of the difficulty is the fact that I think liability under Section 2, which is what Jingles is sort of set out the plan for, the model for how to adjudicate. The failure to draw a majority minority district on a certain set of circumstances gives rise to liability under the statute. It's difficult, to my mind at least, how do you define liability under that statute if the intentional creation of a majority minority district is itself unconstitutional, which I think is where some of the justices certainly are, and very likely a majority are likely to find themselves. So it's not just striking down the remedy, it's striking down the standard that since the mid-80s and arguably before that constituted the basis for liability in the first place. Could they hold on to the liability standard and just say you need a different remedy? I guess it's just hard to imagine how the way the standard's been described and developed over all these decades could survive if, in fact, the court answers the question it posed, yes, that the intentional creation of a majority minority district is unconstitutional.
Thank you for that. I'm not going to put Deuel or Sam on the spot since they have cases before the court and ask them to predict what's going to happen. But I want to pick up starting on Ellen's point and imagine that the court does narrow significantly Section 2 or changes the remedy. And I'm wondering about, from your point of view as litigators, what it would mean to still have the ability to sue for intentional race discrimination under either the 14th or 15th Amendments. I mean, the whole reason for Section 2, back in 1980, the Supreme Court decided a case called City of Mobile versus Bolden, where the court said that they were reading the requirement when you bring a vote dilution claim to prove intentional dilution. So and then Congress responds by creating the effects test in Section 2, which was meant to get around this. So it would be kind of ironic if the court reads Section 2 as requiring it, proof of intentional discrimination. But putting that aside, just thinking about this as a constitutional matter, would it be hard to prove in these kinds of cases intentional racial discrimination? There was such a claim in the Texas case that was decided today, and the court didn't reach it. Deuel, do you have some thoughts on that?
Yeah, I respond to two things. So one is the question you asked, and then two is something that Professor Katz said about what the remedy would be. So on proving intentional discrimination, I think it's incredibly difficult to do. Very rarely are plaintiffs able to prove intentional discrimination cases because, and the Congress says this in the 1982 amendments when they amended the Voting Rights Act to make clear that it only requires proof of discriminatory results, that judges don't like calling legislators racists. I don't think that that's not necessarily what it requires to prove a Voting Rights Act violation or a constitutional violation, that someone was racist or showed racial animus, but it does require you to show that a state was acting with the intent to specifically make it harder for a particular group to vote. And judges are often uncomfortable doing that. In the Alabama case, for the reason why it's back in the Supreme Court is what happened there is even after the Supreme Court said there was a Section 2 violation, Alabama refused to draw a second majority minority district, and instead they drew a district that's about 39% white, or sorry, 39% black, and drew together a community in South Alabama for what they expressly said, the legislature expressly said was race-based reasons. They were trying to keep together a community because of its French-Spanish colonial heritage. And so after the state did that, we went to trial again. I'm going over this for a reason. We went to trial again, and in May, the court came down with a decision saying that Alabama had intentionally discriminated. And there it was, I think, only because of the very unique circumstances in Alabama, right, where you had the Supreme Court saying there was a violation, the legislature refusing to draw a new map, and then the legislature coming out with findings in which they were saying they weren't going to draw a new map for Black voters, but they were going to prioritize this French, Spanish, essentially white community, and do it at the expense of the Black community that the Supreme Court had said deserved a new district. In a circumstance like that, a court can find a court has a reason to find intentional discrimination. Often, though, you're talking about cases that are a lot more amorphous, right? Where circumstances like Samantha described, where you have an existing minority opportunity district or a very clear minority community, and the state is sort of drawing funny districts around it to do anything but draw a new minority opportunity district or to maintain an old one. Those also, I think, are cases where, it's a closer call, but that courts are very often reluctant to make that ultimate finding. And that was exactly what Congress was worried about. Congress knew that courts would be reluctant, that it's also very easy for legislatures to hide what they're doing, right? They can claim legislative privilege. They can say they were doing it for partisan reasons. There are so many other reasons they can say that they were doing it that don't necessarily reveal race. And that makes it really, and then also particularly with state legislatures, you're talking often about hundreds of people. So whose motive are you talking about? And that's exactly why Congress wanted to make it easier. I just want to very briefly say, with respect to if the Supreme Court does say that you need to draw race neutral or race blind remedies, in some cases recently, courts have drawn those kinds of remedies. They've essentially said we're going to draw remedies based on communities of interest, based on socioeconomic data, based on partisan data. Those districts are not probably the districts that perform as well as other districts, but they are districts that do create new opportunities. And so it's at least one thing that in our briefing to the Supreme Court, we pointed out that that's at least a possibility, and it is what some courts have been doing in recent voting rights cases.
Thank you for that. And Sam, when I was researching for my 2024 book on a constitutional right to vote, what I was struck by how, you know, if you look at cases even today in Indian country, they remind me of cases I read about what was going on in the 1960s in Alabama. Like things are really bad. Like it seems like you'd have an easier time just because there's more overt statements that are made that seem to be intentionally discriminatory against that population. Is that your sense?
Yes, things are really bad. But things are really bad. But I don't know of a NARF case protecting Native voters that, we proved intentional discrimination. It's like near impossible. It's just not something that's there. Even with these, overt, at-large districts that obviously dilute the minority vote and extremely racist statements. Like, for example, in Choteau County, um, the county is actually proposing legislation to move the reservation to another county, like move the county lines. It like the measures that they'll take are so extreme in order to not have minority representation on the county commission. We had to write that into the consent decree that if they move the county lines, that haven't been moved since they were established, 150 years ago or whatever, that the case is moot. Like that's, they're just like, okay, just get out. You want to sit at the table, just get out. So, even with that, we settled Shoto before we went through discovery, so I don't know what we would have found, but I doubt that we would have found anything to support an intent claim. And no case that I've litigated at NARF or that NARF is litigated, there has not been an intent claim proven. It's too difficult.
Thank you for that. Ellen, I want to come back to the Texas case, which you and Deuel briefly alluded to. So there, we haven't all digested the opinion. It was 160 pages. There's not even a dissent yet, and it came out an hour before this. So I'm not going to hold anybody to like a detailed analysis, but the court did say it was a racial gerrymander, and kind of the usual defense that we see, and we see it in Louisiana versus Calais, is the state says, no, it was a partisan gerrymander. And like on the surface, that looks right because Donald Trump said, draw me 5 more Republican districts. And that's exactly what happened. So like, could you just explain, like, how did we get here where when it seems like the Texas legislature was trying to benefit Republicans, 2 of the 3 judges concluded, and including a Trump appointee, I should say, on that panel, 2 of the judges concluded that it was actually race that predominated in drawing the lines.
So unlike you, I haven't read the 160 pages yet. I don't have that, but I guess, in some ways, I think it goes back to what you were just saying about the relationship. If Section 2 is cabin to intent, where do we have intent? When President Trump floated this idea of new districts back in June, Texas officials were pretty lukewarm on the idea of redistricting, feeling that their plan was already a partisan gerrymander and had spread folks pretty thin. So DOJ intervened and issued this letter saying, oh no, your plan is a violation of the Voting Rights Act and itself is unconstitutional. And that sort of got the wheels turning. The governor came in and said, we need to call the special session and said, we need to address the constitutional violations, the illegality in our current plan. Attorney General Paxton then came in. It was just sort of a remarkable series of events, comes in at that point and says, sure, we should go forward, but you should all know we had a race neutral process when we drew these lines, or that was a stance that Texas was maintaining an ongoing litigation about the plan. Texas legislators had testified under oath. We did not consider race. And that's where we're going to get the question you just posed, because when they said that, that eliminated, as a matter of law, for reasons we've already been talking about now for a bit, that there could not be a constitutional violation. If Texas did not consider race when it drew this map, and no one's backtracking from the original map, from that stance, it could not have violated the Constitution, so it said. And yet it proceeded with this redistricting. And along the way, what it really ended up doing, and we can get into the weeds and talk about the claims and why the DOJ letter is frankly so, I'll just say, disingenuous as a source of legal analysis. What Texas ends up doing when it adopts this new plan is it targets districts in which minority voters had a meaningful opportunity to participate, albeit one that by the time last summer rolled around was not one they were entitled to under the Voting Rights Act. They didn't have a claim to the districts they were in that the Voting Rights Act required it. But at the same time, they were enjoying, or they were, there was a certain amount of participation going on. And Texas targeted them, DOJ targeted them for that reason. And that's where race gets introduced into this process where it wasn't before. Texas wasn't doing anything, and in many ways, I mean, or at least claims it wasn't doing anything based on race. And it might have, absent the DOJ letter, just engaged in a partisan, redistricted because it was a partisan gerrymander. Rucho says it's fine, and for decades now we sort of have come to that point that say party not race, and you've written about this extensively, Rick, like say party not race and you'll be fine. But instead, the governor said, and the process went forward, say race. We're looking at race. We're looking at these districts that we believe to be unconstitutional. And I, without having read the opinion yet, suspect that's where the court ends up saying that this was a targeting. And it's curious, you look at some not very old Supreme Court cases like Bartlett versus Strickland, where the court there said, Voting Rights Act doesn't require the type of claims the plaintiffs wanted in that case, the type of districts the plaintiffs were arguing for in that case. At the same time, were the state to target districts where that type of participation was happening, that would raise serious constitutional questions. And I think that's how this case is percolated up to this point.
Deuel, I think you said something about what the Fifth Circuit had done before this in terms of coalition districts between like Black and Latino voters. How does that play into this whole analysis?
Sure. So what the Fifth Circuit said, I believe it was last year in a case out of Galveston, was that you can no longer bring what are essentially called coalition claims. And those are claims in which you can't draw a majority Black district in a city or a county or a state, but you could draw a district that is both majority Black and majority Latino. And beginning in the late 80s, the Fifth and the 11th Circuit and several other circuits had said that it's perfectly fine if you can show that Black and Latino voters, for example, are actually vote the same politically, experience similar forms of racial discrimination, and actually have a community together to draw them together into a new opportunity district. The Fifth Circuit, though, sitting en banc, meaning the full court, reversed itself and said that those claims are no longer constitutional, or excuse me, no longer viable under the Voting Rights Act. And so part of what Texas and the DOJ's argument was, is that because the Fifth Circuit said that coalition districts were no longer, that you can no longer bring those as viable Voting Rights Act claims, that the fact that there existed essentially coalition districts in parts of Texas was per se unconstitutional, which is sort of a deeply warped view of Voting Rights Act law, that because you can't be forced to draw something, that your decision to draw something is per se unconstitutional.
Yeah, I mean that it certainly seemed pretextual and orchestrated to create this partisan gerrymander. My view has always been that these race in the American South, race and party are inextricably intertwined, and so the whole idea that you're going to try to disentangle them becomes a very difficult task to do. There are a number of questions in the chat. Some of them are ones I was going to go in this direction. Let me start with the timing question. Someone asks about the Purcell principle. This is the idea that courts shouldn't make changes close to the election. It's a rule that originally the court only applied to like election administration issues, like whether you can strike down a voter ID law or something like that. But we've had a couple of cases, at least, I think both Allen versus Milligan itself. No, yeah, I guess Allen versus Milligan and in the Calais case, where the question is like, is it too late to make a change for the next election? So how is all of this going to play out? I can't think of another time where a case like Calais is just like hanging over an impending election. It's just like the timing, it just makes things really tricky, regardless of what the court does on the merits. If they make any kind of change, that might spur a round of redistricting again, but it also might mean that, to go back to Deuel's point, like just because you did it because the Voting Rights Act, you were trying to avoid liability under the Voting Rights Act, you're still permitted to do that unless race consciousness is now something you can't even do at all in redistricting. So how are we supposed to disentangle this mess and understand how the Purcell principle might affect the timing of all of these challenges? I don't know who wants to. Ellen, do you want to start with that?
No,
You're muted.
not really. I mean, I like they'll say what they'll say about Purcell. I would be surprised. I mean, you mentioned earlier this, this case comes out today without a dissent, and there's some speculation that it's trying to get the case up to the court before the court might invoke Purcell. I can't imagine that the Supreme Court could hand down a decision without dissents to sort of circumvent Purcell. I would be surprised if we'd see Calais in January. Who knows? But it's a complicated case that's going to be highly disputed. And if it makes it all the way to June, difficult to imagine that could spur the kind of round of redistricting. So it's a useless answer. I have no idea how this will play out. The election earlier this month, put a little damper on some of the enthusiasm for redistricting, so that even if Calais came out in a way that minimized or limited further the obligations of jurisdictions to have districts that the Voting Rights Act had previously required, whether states are going to want to, redistrict so quickly at this moment, given all the uncertainty. Is that like a glass half full? I don't know. I even know how to phrase that. So yeah, I should have not just said I don't know the answer. It's how this is going to play out.
Yeah, about it would be kind of ironic, and I have a piece talking about this that's coming out later today in Slate with a co-author, a student of mine, Matthew Cook. There's a question about you could end up with the courts deciding that what Texas did is likely a racial gerrymander, but what California did is a partisan gerrymander, and then you end up with Democrats ultimately getting an advantage in this redistricting war that was not, I think, what Donald Trump was aiming for when he started down the road. But let me ask you, am I correct in remembering, Alan, that you clerked on the Supreme Court? And so how, maybe if you, like speaking generally, not to give away any state secrets here, how long can dissenters stall the putting out of a merits decision? Like, could it really be like if there's, let's say there's a blockbuster voting rights case and there are three dissenters who want to stall the outcome, whichever way it comes out, can they control the calendar in that way?
My experience is ancient, so I wouldn't speak to anything that was going on now. And when I suggested, I think that Calais, I'm not going to answer your question. I mean, when I think Calais is going to take a long time, it's not because anybody is stalling. I think actually your question earlier got at this, like exactly what are they going to hold? They could strike the whole thing down, but if they're going to hold something else, that the use of race was too much, that the use of the deliberate creation of a majority district involves a consideration of race in a way that I think a majority of the justices are uncomfortable with. And yet, and further to say, and it's not something that Section 2 of the Voting Rights Act can justify, can support under strict scrutiny. That's already a super complicated opinion. I think you're right that there are three justices, at least, who would dissent from that, possibly more. And it's a complicated, it's not a case that invites an easy opinion. So I'm saying I don't think anybody needs to stall to sort of work that all out. Do you have to overrule Jingles? Do you have to overrule Allen versus Milligan? Do you have to overrule Blulock versus Perry? I mean, how far back do you have to go? I mean, I'm going to go further and say 50 years ago, more than 50 years ago, in White versus Register, unanimous Supreme Court held this is racial vote dilution in circumstances that under a standard that becomes a Section 2 standard in 1982. The court's now going to say, sorry, not anymore. I mean, there's some chance of that where because there's a two-party system, because the jurisdiction can say, oh, it was party, and we're going to draw a line right through this cohesive, geographically compact minority community where you click off every single box from White versus Register, click it all off, but there's two parties, we're done. There's no injury. I can write that. It would take a while. And a dissent from that will also take a while. So I don't think there has to be any sort of inside base, like who's going to be stalling and manipulating. I think, dealing with all that's going to take a long time. And I anticipate a really long opinion. Now watch, it'll be an 8-page opinion that will come out in December. Maybe. I kind of doubt it. So yeah, it's complicated. So I think the complexity of the case will take time.
Well, so let's take this idea that Kelly is going to be hanging over, not decided. So I don't know if Sam or Deuel have thoughts about this Purcell timing question. Like, when is it going to be too late to get remedies either for re-redistricting or for the many pending Section 2 cases that are still out there?
Yeah, so I think just, the Supreme Court in Milligan stayed relief for it was early February for the November elections, and said that it was too close to the then upcoming primary, which was still, I think, at that point maybe 2.5 months away. And then in Calais did something similar, except it benefited my clients that time around, in which the the district court had struck down the second majority minority district, and I think it was like for March or April. And then the Supreme Court said it was too close to the then November general primary in Louisiana for a new map. And so, you know, Purcell has been used in different ways at different times. I think mostly to the detriment of voting rights lawyers, but sometimes to their benefit. I think what's interesting, not necessarily a Purcell question, but a related question, is that states are often telling us, right, when we bring these lawsuits, it's too late to redistrict, it's too late to do new things. And what's happening in Louisiana right now is the legislature has already pushed back several of the election dates to sort of make it easier, and that they have also been considering other bills that would push the dates back further, with the idea that if they do get the Supreme Court's decision, on January 10th, that they can still push things back a couple of weeks and redistrict in a way that they like, right? And so oftentimes states are sort of complaining about how it's too close to the election. We can never change any of these election dates. It's all set in stone. But when there's something that, they think is going to benefit them, some decision that they think is going to benefit them, they're often able to move more quickly to change election dates, to change maps. And I think that is the sort of thing that I'm anticipating you'll continue to see in a lot of different states, about sort of moving around some election dates in anticipation of Calais coming out a way that states like.
So it's kind of Purcell proofing by changing the dates on the other end.
Exactly.
So I don't know like what this means. If it was February in Milligan, like what it would mean for the Texas case. I can't imagine Texas is not going to go right to Justice Alito, Fifth Circuit Justice, try and get a stay. So that's going to be resolved, let's say, within the next 3 weeks. That would bring us to the middle of December or early December. Seems to me like that's not a Purcell problem. So then if they're going to reverse, they're going to have to do it on the merits. But what do I know? But that seems like a really long time away. I believe it was in the Milligan case where Justice Kagan dissented publicly from that stay order and said, "Hey, we've never applied this to redistricting, and there's so much time before the election." But the reality on the ground is, I know this in California with this redistricting going on out here with Proposition 50, that candidates today, like they want to know where they're supposed to run, and they're like figuring out how they're going to run their campaigns. And it's very different if you don't know what the lines are. So one of the things that you probably haven't seen yet, I will flip through the Texas decision, is rather than remand it to the Texas legislature to draw maps to comply with the likely violation, they said, there's no time. We're just going to adopt the 2021 maps, which are still subject to other litigation, but that's what you already did. So that's what we're going to revert to. And so that certainly saves some time rather than giving Texas a month to try to fix it. Sam, I don't know if you have any thoughts on this timing question and what we're likely to see.
Yeah, I think just like Deuel said, there's no real, test for Purcell. Like it's any way, which way, and usually not benefiting plaintiffs. But it's even without Purcell, it's still going to affect litigation on the ground. Defendants are still going to move to stay cases. There will be agreements to stay cases. Courts are still going to want to stay cases after judgment is entered before the remedy. is imposed, or even before judgment is entered, just from now going forward, based on, not just on Calais, but also this private right of action issue. Like in our Shoto case, the county demanded that we include a clause in the consent decree that allows them to reopen the case in the summer if the court decides that DOJ, is the only, there's only standing with DOJ. So, they're just going to continue to push this, and it's going to be something that litigants will have to face, before they even get to the merits of the claims.
Yeah, if my memory is correct, back in, this is not from my current memory, but from reading about it, in 1964, when Reynolds versus Sims was coming out, the Supreme Court basically said, don't apply this to the upcoming elections because it's just too soon, but it's going to apply for elections going forward. And that kind of gave a 2-year window. I think whatever the court does, if it makes a change, to the extent that it feels like it could do that prospectively without issuing an advisory opinion or something, it would be useful for election administrators at the very least to be able to know, like, okay, we're set now, and like whatever litigation there is, we can work it out for the next couple of elections. So maybe we'll see that. We only have a couple of minutes left, and so I just thought I would end by just asking you, to each, tell me, what you're looking for, what you expect as we enter into the 2026 elections. I can't think of another period of so much uncertainty. Ellen, do you have something you want to say, or is it just like, that emoji where you just throw up your hands and who knows what it means?
That's my instinct. We've been seeing the erosion of the Voting Rights Act for, you know, since the mid 1990s at least. And death by 1,000 cuts, and we've seen it again and again and again. And so you sort of wonder at this point what will happen. So I wouldn't hazard a guess of what's going to happen in terms of sort of electoral outcomes, but also just in terms of, as you pointed out, for all the reasons, the structures that are in place. You said something earlier, and maybe this is worth flagging, that Indian country sounds like old style discrimination, and I think one of the outcomes we could see today, and from the Calais case in particular, and Turtle Mountain for that matter, is a return to sort of the practices that were in place that Congress set out to outlaw. We could sort of see license to engage in them, to engage in precisely the kind of activities. And as long as you don't say something blatant and you say party, not race, there'll be immunity for it. So that's not a cheerful closing thought.
Yeah, maybe we don't end with that. Let's see if Deuel could do better.
I remain hopeful. Obviously, we've been representing the clients in Calais and Milligan and a number of these other cases. And I think the court, in the argument, the justices were asking sort of what would be the result of this. And I think one thing that is troubling, but at least gives me some hope that the Supreme Court will look over the edge and decide not to jump off of, getting rid of the entire Voting Rights Act, is that even the U.S. Solicitor General in its brief wasn't suggesting that the Voting Rights Act was unconstitutional. Now, they were talking about severely hampering it, but they did not say that the Voting Rights Act was unconstitutional. They didn't say that any use of race was unconstitutional, and they left open the possibility that, there would be a narrowing of the Voting Rights Act, which we obviously were fighting against, but that would still leave open the possibility for Black voters, Native American voters, other voters of color to bring these kinds of cases and to win. And so I'm hopeful that the Supreme Court will do what they did in Milligan, a couple of years ago, in which everyone was saying, the Voting Rights Act is going away, the Voting Rights Act is going away, and it didn't happen. So we'll see, if the court will pull back again.
Sam will give you the last word, and let's not ruin the sort of not pessimistic vibe.
Oh, that's a tough. Okay. I know I actually do remain hopeful as well. But best case scenario is things stay as is, right? There's no like movement forward, but it's a status quo. And like racial discrimination still exists. Like these stories are still there, and the facts of the reality have to fit what the Supreme Court is doing. Like it has to go together. And I think that at the end of the day, it's too much of a stretch to not deal with the facts. So I have hope too.
Well, I learned a ton. Maybe I'll have you back in a year and we can kind of dissect what's happened. Maybe there'll be re-arguments in Calais. So, there's a lot of do-overs these days, and when it comes to voting rights. Um, Ellen Katz, Samantha Blencke, Deuel Ross, thank you so much. Really appreciate it. And we'll see you all again next semester. I'm Rick Hasen. Take care. Bye, everyone.